Professor Tribe, let me begin with you. The judge in her ruling refers to this as, quote, a complex case of first impression. Is it a complex case of first impression? And does that explain the judge's rulings so far?
Lawrence, it is not at all complex. I'm not sure what she means of first impression, other than that no one has ever tried to use the Presidential Records Act, which was passed after the Watergate episode, in order to make sure that all official records of the presidency would go to the National Archives. No one else has tried to use that civil statute as a way of defending themselves against criminal charges. The Presidential Records Act has absolutely nothing to do with the case. But I think you put your finger on it when you notice that she used the word pre-trial. When she said that he's not entitled, the special counsel is not entitled to a pre-trial ruling on this matter, a pre-trial determination that the Presidential Records Act is inapplicable. What he wants is a determination, period. It's not a question of pre-trial. If she makes that determination once the trial has begun, once the jury is sworn in, once double jeopardy is attached, there will be no possibility of reviewing what she does. So she has essentially said, I'm going to pretend to be ruling against Donald Trump. And he understands that it's just a pretense. I'm going to pretend to be ruling against him. But what I'm really doing is reserving the right to rule in his favor or against him at a time when nothing can be done about it. So she's basically trying to have it both ways. It's too clever by half. When she says the pretrial, the Presidential Records Act provides no basis for pretrial dismissal, she's suggesting that it may provide a basis for dismissal during the trial. That's clearly wrong. That is why it's very clear now that the 11th Circuit has twice very sharply reversed her, that the time has come for it to be asked to take her off the case altogether. The best way to do that, although it's possible to seek what's called a writ of mandamus immediately, I think the best way to do that is to make a motion now to take this issue off the table, not to formulate jury instructions in advance, which he's never asked her to do, but to rule now that the Presidential Records Act cannot be a defense to this prosecution. If she rejects that request, it's called a motion in limine. If she rejects that request, then Jack Smith will have done all he can possibly do, and no one can blame him then for going straight to the 11th Circuit. Some people, I think believe he can skip that intermediate step. But since he doesn't know what panel of judges will be assigned in the 11th Circuit, and there are many on that circuit who might be, though not as biased as Judge Cannon, perhaps inclined to lean in favor of Trump, I think the safest course is for him to demand now that she take the entire issue of the Presidential Records Act off the table. She says no, he seeks appeal and either asks that she be recused or relies, depending on the panel itself deciding that 3 strikes is enough.
We are so lucky to have you both here tonight, both accomplished Supreme Court practitioners yourselves, having argued dozens of cases there. And Neil, having listened to Professor Tribe, I'm now wondering, did Judge Cannon, in fact, by denying Donald Trump's dismissal motion the way she did she actually do the best thing she could possibly have done for Donald Trump at that moment in that one action?
She didn't do the best thing, Lawrence, but she came pretty close. So she styles this as a win for the prosecutor, for Jack Smith, but nobody in the special counsel's office is celebrating tonight because this order tees up future mischief that she can engage in. And in particular, she's refusing to give the prosecution a clean order on the Presidential Records Act, which should have been so easy because, as Larry Tribe just said, of course, nobody thinks that the Presidential Records Act has anything one whit to do with this. I mean, no responsible scholar or lawyer, I think, can make that argument with a straight face, and frankly, no one has. So then the question is, what does Smith do about it? And there's two options for Smith, really. One is, as Larry said, to file what's known as a motion in limine and go to the trial court again, go back to canon and say, please exclude before the trial everything about the Presidential Records Act because it just doesn't apply. The other is to file this piece of paper known as a writ of mandamus and going straight to the Court of Appeals and saying, this decision is so out of whack that you should hear the case right away before the jury gets seated, because once the jury is seated, as Larry Tribe just said, double jeopardy applies. Here's where she didn't make the most powerful thing she could have done for President Trump, former President Trump, because she, in her order, went so far as to say she's not going to resolve this whole question of the Presidential Records Act now, Lawrence. She said it would be, quote, unprecedented and unjust to do that. And she went so far as to say she won't resolve it, quote, prior to the presentation of trial defenses and evidence. So what that means is that Larry Tribe's suggestion of the motion in limine is futile. I think Jack Smith may want to do it anyway just to check the box, but we know what the result is going to be because her decision today says she's not going to resolve that question until after the trial begins and after the evidence gets heard. And by the way, it is so ridiculous for her to call this unjust, what Smith was asking for, and unprecedented. Remember, she's the one who asked Jack Smith to opine on the Presidential Records Act. She, on her own, sent this bizarro, two different jury instructions to both sides and said, comment on them, please. So Smith did what he was told. He commented on them and said what every lawyer believes, which is the Presidential Records Act has nothing to do with it. And then she calls it unprecedented and unjust. I mean, at this point, I've certainly seen enough. I think, my guess is the prosecution has seen enough. Maybe they'll check some boxes and go with the motion in limine. But one way or the other, this is going to the 11th Circuit.
Hey everyone, MSNBC has a new and improved app. You'll get real-time alerts and analysis, live blogs, in-depth essays, video highlights, and the best 2024 election coverage. Download the new MSNBC app. Here's how to do it. You tap on the App Store on your phone. You hit search on the bottom right corner. You type in MSNBC. You click on the MSNBC app. You click on Get or the cloud icon and enjoy it.